Be seated. Good morning. Now's the time set for oral argument in cause number 1CA CV160441FC. For everybody's information, these proceedings are being both audio and video recorded. There was a time when we actually kind of got a blank look back. I think everybody's pretty used to that now, though. Barring any problems with the system, you ought to be able to critique yourself on YouTube or review for client purposes, whatever you deem appropriate in a couple of weeks. Counsel, each side will be entitled to the normal 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant, if you wish to reserve any of your time, please let us know so we can avoid taking up all of your time. We will take up some of your time. We will try not to take up all of your time. However, ultimately, your reserving of rebuttal time will be up to you. We've reviewed the briefs this morning. We have conferenced the case this morning. So we are well aware of the facts and issues attendant to the argument. We say that so that recognizing that that is the case, we'd ask that you fashion your argument accordingly. Counsel, when you come to the podium, I would ask that you state your name, that you indicate who you represent, and with that, the appellant may begin.
Good morning, Your Honors, and may it please the Court. My name is Jennifer Anderson. I represent the appellant, Karen Yee. I think this is working. I would like to reserve 3 minutes of my time for rebuttal.
Counsel, before you begin, we do have, a series of maybe kind of random questions, and you don't have to answer them all right now. You can, as long as you kind of get to them at some point. It's my understanding that this went to court on a petition and a cross petition concerning the child R.Y., but ended up somehow with rulings about J.Y. So
that's correct, Your
curious
Honor.
how that occurred. We have a question about there's a credit to the father for an amount of $321 that we don't understand. And then we're also curious as to whether there's any evidence in the record of what father's income is.
Well, thank you, Your Honor. I appreciate that, and I'll get to those questions right away. We simply don't know how it ended up affecting J.Y., the older son. There's no...
At the time that order entered, how old was J.Y.?
He was 17 years old, and he was a junior in high school.
Okay.
And so he had another full year of high school left. He graduated in May of 2017 at the age of 18.
That's this year or last year?
This year. So he graduated in May of this year at the age of 18. So basically, there's a little bit more than a year of child support that hasn't been paid that's owed for JY. And so that sort of leads me, and I will get to all of your questions, but, well, why don't I address the next one because it's kind of related.
However you wish to do it.
As far as the $321 credit, frankly, again, Your Honors, we don't know where that came from. To be honest,
there's a reference to an obligation for other relationships, but we don't know what that means.
Or that applies.
It does not apply, Your Honor. There's no dispute that father had no other children from other relationships. There was no evidence presented. There was no testimony about children from other relationships.
But the 321 perhaps related to father's obligation regarding JY.
Well, that is certainly father's argument at this point. It's not an argument he made in the family court when mother included the issue in her motion for new trial. But there's a couple of problems with that argument. The first of which is that father was never ordered to pay $321 a month for support for JY, and in fact has not been doing so, and that is undisputed. The second problem is that going into the March 2016 hearing, mother reasonably assumed that the only thing that was going to change would be parenting time and child support for RY, because even in the the family court's ruling, April 18th ruling, she says that the proceedings solely concerned RY, and yet there's a termination of child support for JY, and we assumed that that was an error, an oversight. Maybe she confused this case with another. Father's position is that is his child support obligation. What
is his child support?
The 300. I'll let Father's counsel articulate what his position is, but my understanding is that the $321 is supposedly Father's child support obligation for JY. The problem is Mother had no notice or opportunity to be heard about any reduction in child support for JY. She had no idea going into this that his child support would be affected in any way, and that's why it's so important to vacate the child support order, remand for a new hearing on child support both for JY and for RY, because there are errors concerning that order as well. Excuse me. But Mother has had no opportunity to, for example, present evidence of expenses that she incurred for JY in his last year of high school, which, he's getting ready for college. He's got college application fees. He's got other school-related fees as a senior in high school. And so,
as you proceed, would you do us a real favor and advise us at what point there is evidence in the record?
Okay.
Okay, as to these things, because that's another problem we're dealing with.
Yes.
It appears that every issue we go to, we can't find evidence in the record to support it. So where it exists or where it does not exist, would you please be clear on that?
Yes, Your Honor. There is no evidence in the record concerning child support for JY, expenses for JY. Mother had never had an opportunity to present that evidence because she had no idea that child support for JY would be modified, much less terminated.
Is there a worksheet?
There was a worksheet.
Did it deal with a $321 or whatever it was support order?
It simply said, and that's actually Appendix C. I don't know if you have a copy of it, but I think it's Index of Record 254. So on the child support worksheet, there's a line to put in an amount for child support obligations of children of other relationships, and that's what the judge put in, the $321. I have no idea why she did that. We don't know. There was nothing at the hearing in the parties' submissions regarding that. There is likewise no evidence in the record that Father was making only $400,000 a year. He's a medical doctor. Mother indicated that she suspected he made at least $400,000 a year, and she requested financial disclosures, which are required under Family Law Rule 91. She requested disclosures, and the exact disclosures required are 91P2, but the judge refused that request and simply assumed that he made $400,000 a year.
So we're clear, $400,000, to my understanding, was only raised in a pretrial filing by Mother.
As an estimate, as simply an estimate, she's saying, I suspect he makes at least this much, but I don't know, and I'm requesting financial, and that's in her pretrial position statement.
Was testimony taken to support his income at the subsequent hearing?
No, Your Honor.
So just on a fly, there's a statement, the pretrial statement, the judge adopts that without testimony being taken on the issue of Father's income.
Well, let me back up. So Mother's counsel did try to get into the area of his income, and I can give you the exact pages if I go grab my notebook. She tried to ask him about financial information, but basically his counsel's position and his position was he wasn't required to divulge that unless the court modified child's parenting time, in which case there would also be a modification of child support. However, the court did in fact do that, and yet he still did not disclose any financial information.
Parenting time was modified, but the child support amount did not get corrected accordingly.
It did not, there was no disclosures for the trial court, for the family court to rely on one way or the other whether that was accurate. There's nothing in the record. Father argues that there were disclosures at the time of a July 2015 stipulation and order, which
Are
was...
they in the record?
No.
Thank you. Go ahead.
think we've gotten through most of the points I wanted to raise.
But what you just said is the court did not allow mother to inquire about father's income, even though, as I understand it, father had cross-petitioned to reduce mother's parenting time and to reduce child support downward.
That's correct. And so in her pretrial position statement, mother makes an express request for financial disclosures from father. Then at the hearing, on page 239 of the transcript, which is supplemental appendix 88, mother's counsel begins asking father, I'm asking you for this hearing today, did you provide me or this court any financial information whatsoever? Answer for today, question yes, answer no. Well, isn't that your, and then on page 240, isn't that your position in your position statement? Father believes that no financial information should be exchanged until this court decides if child parenting time is going to be modified. Yes. And then counsel for father argues on page 268, unless this court makes a decision today to change parenting time, the information regarding father's current financial information is only relevant if there is a change.
So he wanted like a bifurcated proceeding. First a determination there would be a change in parenting time, and then he would acknowledge being obligated to provide financial information.
Frankly, I'm not sure, Your Honor. I was not counsel in the family court, so I don't know exactly what discussions went on. It certainly was not submitted an affidavit of financial information. She submitted employment information, so she never agreed to a bifurcated proceeding. She disclosed the information, but father did not, even though there was a change in parenting time.
Correct me if I'm wrong, counsel. Doesn't case law state that in the event the court modifies the parenting time arrangements, makes a change that will impact the support amounts, that at the same time that it orders the modification, it must order the modification of the child support as well?
Well, that is correct, Your Honor, but there are a couple issues that came up here. Mother, because of that fact, reasonably expected that she would receive financial disclosures from father, which she did not. So she was not able to cross-examine him on his supposed income. She suspects that he may be paying his wife a paycheck from his business, because that is what happened with the parties when they were married. She has had no opportunity to scrutinize his disclosures.
But my question goes more to the issue of the court.
Yes.
Isn't it the obligation of the court at the time of the modification of the parenting time to modify, consistent with that modification, the child support issues?
Yes, Your Honor, so long as, obviously, number one, as long as there's sufficient evidence in the record to modify child support, and if there's not, the family court has an obligation to make sure it gets it. Number two, that does not apply to a child whose parenting time is not being modified. So yes, mother could reasonably expect that child support would be modified as to RY, who is the only child whose parenting time was being modified. She had no reason to believe that child support would be modified as to JY.
A few minutes ago, you said something to the effect that mother requested financial information, but the court did not order it, something like that.
Yes, Your Honor.
Was the procedures, was there a motion, perhaps a motion to compel the financial information? The request at the time of hearing, Judge, he was supposed to have provided it and didn't. Would you order him?
There was a request in mother's position statement filed before the hearing, and let me see if I can get an exact record site for you. And then additionally at the hearing, mother did raise.
I'm not sure that it makes any difference, but
yes, Your Honor.
I'm wondering, whether a motion to compel might have been useful.
It may well have, Your Honor. Again, I was not counsel at that time. I would also point out that the family court has an independent obligation to make sure there's evidence in the record to support its ruling.
And that's kind of, I'm sorry, I didn't mean
No. That's, I just wanted to bring it back around to your question.
There you go. Thank you for that. That's where the thrust of my question was really going.
Okay, I'm sorry.
Is when you recognize that there's a modification of parenting time and custody, or however you want to structure that petition for modification, doesn't that have with it an attendant and an inherent responsibility to not just address the potential for the modification, but also the change in support that would be consistent with the modification if so ordered?
Absolutely, Your Honor.
I've never seen it done any other way. I guess that's why I'm a little
I
incredulous. there.
agree with you, Your Honor. Yes, and mother did. I'm sorry.
Go ahead. No, go ahead.
And mother did make those disclosures, but father refused.
And what I was going to say was I've never seen that bifurcated before, so I guess that's kind of surprising to me. I have done a few of these on the Superior Court bench. I've never seen it done like that. Thank you.
Thank you, Your Honor. Unless there's any more questions about those issues, mother believes that the proper remedy here is to vacate the child support order and remand for a new hearing on child support. She has a due process right to present evidence and elicit testimony and cross-examine regarding father's income. She should be able, if, for the modification of JY's child support, she should be able to present evidence of expenses for JY, unusual costs for him. And in cases such as Heidbreder, where the family court did modify child support without giving adequate notice, that was the remedy, is to vacate the child support order and remand for a new hearing. And so we asked that. We also respectfully request that the court award attorney's fees to mother. She should not have had to hire an appellate attorney to get child support to which she was entitled for the support of her minor son. Father's positions are unreasonable. They are not supported by the record or by case law or statutes or rules. And the disparity in income between the two parties is in Appendix C, which I believe is Index of Record 254. There's no dispute that father makes at least $400,000 to mother's $95,000 a year. So that's a 4-to-1 disparity. And so we respectfully request attorney's fees as well. Unless the court has any more questions, I'll sit down.
Thank you, counsel.
Thank you.
It's your go, counsel. I don't think there are a lot of surprises for you as to where our interest lies at this point. So, following on Judge Thompson's initial presentation, you might want to help us out.
Okay. Well, good morning. May it please the court. My name is Mary Kay Grenier, and I represent Martin Yee, who is the petitioner and father in this matter. So, to address your questions, a couple of things. I think it's important for the court, with respect to your first question about how RY and JY got into this together when the petition to modify pertained only to RY. 23 days prior to mother filing a petition to modify legal decision-making, parenting time, and child support, we had just gone through a comprehensive and complete exchange of financial information between the parties, and we had voluntarily agreed to modify child support. At that time, JY was living with mother, and RY had 50-50 parenting time with both parents. We were operating under an old child support worksheet that had both kids 50-50, and the recognition is that the parties needed to enter into an agreement that recognized that JY was with mom and RY was split between the two. So in the summer of 2015, we engaged in significant financial disclosures. And I say significant because father is a physician who's a contract doctor with a hospital in Tucson. And so financial statements, profit and loss statements. It's not just a paycheck attached to an affidavit of financial information.
This is all off the record, though, right? This doesn't become part of the record?
It was all off the record, but the important part of that is that it was all in mother's possession. We didn't dispute, we didn't challenge that either parent's income had changed. We took the position that if there was a modification to parenting time, then child support would be modified accordingly. And I sincerely believed that at that point in time it would be done by agreement of the parties, not by order of the court. Or at that point in time, we would assess the situation, the financial situation of the parties, because both parties entered into their petitions with the position that child support should not be modified unless there was a change to parenting time. That was in mother's position. It was an if-then. If parenting time is modified, then child support should be modified, and father had the same position.
But did mother ask in some fashion at the hearing for the court to order production of an affidavit of financial information and other documents regarding finances?
I don't think she asked the court to order it. I think her position was that, in fact, I know her position was at the time of trial, it was made in the context of attorney's fees. She was taking the position that because father had not filed an actual affidavit of financial information, that he was precluded from asking for attorney's fees. And that's largely where the discussion about an affidavit of financial information came into the context of the case. With respect to the exchange that took place between father and mother's counsel, mother's counsel simply conceded that father had not established or provided financial disclosures as part of this hearing, but failed to recognize that he had just provided them and had given them to mother, and they had decided not to make them part of the court record.
But counsel, can't we agree that this is a secondary, it's not secondary, but a second proceeding that is seeking a modification of the issues that would give rise to the potential change of financial support, correct?
Right?
Was good so far?
Wait, say that again. Are you talking about this particular one, or are you talking about the trial in March?
I'm talking about when we get to the point to where mother objects that she didn't get the income information she needed from father.
Right.
By the time we get to that point, can't we all agree that it was appropriate at that time, based on the rules and the case authority I asked opposing counsel, that the potential for the modification of custody and in parenting time gave rise to the issue of the need to address the issue of income and potential child support numbers, correct?
I agree with you.
Okay. And yet the mechanism wasn't even set up for that to happen. There was no requirement of the presentation of income statements or income documents that would have supported the child support order that the court would have necessarily had to make with the modification, correct?
Not really. And the reason why is because I believe the court is failing to acknowledge that the judge knew that 23 days prior to this petition to modify being filed by mother, there wasn't a comprehensive and complete income exchange. And so mother was well aware of father's income, and we were well aware of mother's income. Nobody contested that at trial.
But where can we find the documents that the court relied upon in coming to that determination, or that in fact that there was a stipulation that the numbers from the prior proceedings or from the prior agreement should be used? Because she certainly wasn't saying use the numbers from the prior proceeding.
Well, that's not true, because in Ms. Cucurullo, the mother's trials counsel's closing argument, she said, last time I checked, father made $400,000 a year. Not, I think he made 400, or he...
Testimony that we rely on?
Well, no, that's not the testimony you rely on, but in the context of the trial, it was crystal clear that father's income was $400,000 and mother's income was about $100,000. There was a discussion that father's income was 4 times mother's income. There was discussion that $400,000 in the pretrial statement was the number that they were using. They didn't pull that out of the thin air. They pulled that out of the financial disclosures that were made 23 days prior
Counsel,
to the
I
filing.
found myself puzzled as to why this proceeding was even taking place, given what you're saying. You're saying, well, there was a resolution of all these issues in July of 2015, and then within a month, both sides are back there wanting everything changed. That's not right?
No, that's not right. So there was a modification to just the child support in July of 2015. There had been a modification to legal decision-making in 2014, where father was given legal decision-making for RY. Then we voluntarily entered into an exchange of financial information to modify child support in July of 2015, and then mother filed her petition to modify legal decision-making, parenting time, and significantly only child support if there was a modification to parenting time. In other words, if the court didn't
to me, that's kind of splitting hairs. So you have a series of existing agreements as of 2014, and then 2015, you wrap it up with a child support agreement.
Right.
And then within a month, everything is all up in dispute again.
That's right.
So why isn't the judge saying, how could there be a substantial and ongoing change of circumstances sufficient to get this thing back into court within a month? That's a little baffling.
Well,
Sounds like you both sides joined that.
Well, and I think what the court needs to understand is that mother petitioned the court to go from a sole legal decision-making
Right.
agreement back to joint.
But then the response is to change it the other direction.
No, the response is to keep it the same, affirm sole legal decision-making, and things had gotten so bad between RY and mother that father was seeking to supervise mother's parenting time to protect the child. And that's in fact what the court did,
And to reduce it.
to take it away,
Yes.
to supervise it.
That's
And
what I'm saying. So she wants more time and more money, and you want her to have less time, and he wants more money.
No, he didn't want any money. He just said, we just took the position that child support should only be modified if there's a change of circumstances with respect to the parenting time.
He was asking for that. He was asking for the change of circumstances, and attendant upon that would
Oh,
be.
indeed, indeed.
And that's always the case.
I'm still puzzled why this was in court a month after it seemed like everything was.
But it
resolved.
wasn't really a month after the custody
I got
and
it, I got
parenting
it.
time things were addressed. It was
Just
a
that-
while.
It's just in July 2015, the custody visitation arrangement was sufficiently established that you worked out what the child support should be based on that. So to me, that's something of a ratification of the existing deal, and all of a sudden it changed within a month.
Well, and that's exactly why the mindset, and I talk about this in my response brief, the mindset of the parties going into this hearing was not child support. It was not an exchange of financial
Yeah,
information.
but if you know that's going to be an issue because you're all arguing about where the child is going to be,
It just-
seems to me you know that that's going to be an issue.
Well, and we knew that that was going to be an issue, and the exchange had just taken place. It wasn't like it had been 2 years since child support had been modified. It was literally within 23 days.
Well, counsel, did you
Yes.
seek a stipulation on the issue of income?
Say that again?
Did you ask for a stipulation on the issue of income? Because absent a stipulation by the parties that they're going to give to the court and say, this is our stipulation as to what our income numbers are, it was a matter that was subject to debate and contest.
Well, and that's true. And in hindsight, looking at that stipulation and order that we prepared, we reached the number of $1,800. This was the July 2015 stipulation and order. We reached the number of $1,800 prospectively based upon the financial exchanges. In other words, I can assure you that that number we didn't wing it. We didn't say, hey, he makes 400, hey, she makes 100,000. That wasn't like that at all. We had an agreement, we did multiple worksheets, and we entered into a stipulation and order. The worksheets weren't part of the stipulation and order at the time that it was submitted, but the parties did agree to 1,800, and we also did not agree as to what part of that 1,800 was attributed to JY, and what part of the 1,800 was attributed to RY.
Counsel, my concern isn't whether or not you and opposing counsel winged it. Is that the way to say it?
That'd be wung it.
Wung it. My question is, did the court wing it? Did the court just simply sit down and make some numbers up? Because we can't find anything to support those numbers that was presented at the hearing.
The answer to that question is no. The pretrial statement filed by mother and our pretrial statement both used the number for father of $400,000. The mother provided an affidavit of financial information that had her income north of $95,000, almost $100,000. So she did not wing it. And I believe that in the minute entry it says, based upon the financial determination of the parties, the court finds the relevant financial factors and the discretionary allowances and adjustments will allow for a current calculation of child support pursuant to the guidelines. So I do believe that the court had uncontested, unchallenged testimony that father's income was $400,000 and uncontested and unchallenged testimony that mother's income was $100,000.
Essentially a stipulation.
Essentially a stipulation, because both of those positions were taken in the pretrial statements and they weren't contested at trial. Look, we had a whole day trial. If mother wanted to ask questions about father's income, she could have asked questions about father's income. Do you make $400,000 of income? Yes or no? Have you made more income in the last 9 months that you made when we modified this child support in 2015? Have you taken on more work? Are you making more money now than you were before?
Inquiries weren't made?
No.
What is the $321 in court-ordered child support of other relationships?
So I
Is that
believe,
just a misnomer or something?
you know, I believe what the court did was a multiple children divided custody worksheet. And I think that the court used that number, 321, to give some money as an obligation for JY. There were 4 numbers inputted by the court in that worksheet. Income for mother, which I've already addressed, income for father, which was addressed and unchallenged and uncontested, the parenting time days, which were de minimis given the supervised access, and it's important for the court to also know that supervised access continues to this day and hasn't been modified. So during the entire duration of the period of time we're talking about, the 13 months, her parenting time remains supervised.
How old is RW?
He is 15.
RY?
RY.
Sorry.
He is 15 and he is a sophomore in high school.
Okay.
And then the 4th number was that 321. And I believe, based upon the testimony that was given at trial, it was crystal clear that Jeremy was in the custody and the care of mother. That is in the transcript. It was in the transcript that was part of a court order that mother is the custodian of Jeremy. There was testimony, unconverted testimony in the trial about mother's income, same for father's income, and then we know that the parenting time was modified. So of the 4 numbers that the court put in that worksheet, there was testimony as to all 4 of those numbers. Not necessarily for the 321, that 321 is a correct number, but there was clear testimony and the court was fully aware that there was another child, unemancipated, in mother's care.
So your position is that father owes the 321, which kind of offsets the 306 or whatever that mother's obligated to pay?
Pursuant to the worksheet, which I think is consistent with the information that was presented at trial, yes.
Anything else, counsel?
Nope. Oh, I do. I'm sorry. I thought too soon.
That's okay. You
I
got
still have
time.
3 more minutes.
You don't have to apologize when you still got time on the clock. Go ahead.
Deal. couple of things. As it relates to attorney's fees, the context of this case is so out of control, I can't even begin to tell you. Mother's been in bankruptcy court on the $65,000 award of fees, $60,000 award of fees that father was giving at the trial. She tried to get those fees discharged. They were ordered to be non-dischargeable. Father's had to go through all of the bankruptcy proceedings with mother. Respectfully, Ms. Anderson is probably the 9th attorney that has represented mother in this action. It is a litigation nightmare. And I would just ask the court, in the context of attorney's fees, that finally Judge Cooper understood the unreasonableness heading into the trial. And as Judge Thompson accurately pointed out, the rush to file a petition to modify just as when we thought that we had things resolved. Yes, we counter petition to modify, but that was because mother opened the door wide open, and there was no way that this court could take this back to joint legal custody where we had just come from the 2 years prior. So
I hate to go back
Yes.
to the 321, but did that, in your position, expire when the judge ordered father's child support obligation terminated?
No, it didn't. It would expire naturally when the child emancipated in May of 2017.
Was it paid until emancipation?
So, no. To the best of my knowledge, I believe there have been a handful of child support payments from mother, and I believe that was at the directive of the bankruptcy court because the bankruptcy court didn't really know what was going on. Father did not pay that child support, and mother did not pay all of the out-of-pocket child support expenses that are owed for RY. So I can tell you that at the conclusion of this hearing, whatever it is you decide to do, there's a whole bunch of clerical work that needs to be done to say this person needs to pay this person needs to pay that, and then we need to offset those with other child support expenses that will be calculated.
And is it in the record as to JY after, I guess you said May 2017, is he living with mom still? Is he working? Is he in college? Going to go to college? Is there anything in the record about that?
No.
All right.
No, the only thing in the record was that 46 seconds. The only thing in the record was that the child was living with mom full time. My last thing, and I'll say, the last page of Ms. Anderson's reply brief indicates that we did not try to settle this and that I was unwilling to settle the matter. And that is untrue. I think if you ask Ms. Anderson, we did try to settle this. And I did try to discuss this issue with Ms. Cucurullo, mother's trial counsel, before Ms. Anderson got involved. So because that was on the last page of her reply brief, this is my only forum to be able to tell the court that we did try to resolve it.
I was about to ask whether you and Miss Anderson would go out in the hallway and settle it right now.
If there weren't so many other things, bankruptcy, attorney's fees, pending attorney's fees applications, I mean, if there weren't so many other things impacting, we probably could. But unfortunately, we still have a long road to go.
I'm not holding my breath.
Thanks, counsel.
Thank you.
Briefly, Your Honor, I can assure you that after the April 18th ruling came down, we did approach father's counsel and try to convince him to voluntarily pay the child support, and he refused. Was
there any point at which it was deemed appropriate that the non-payment by father was an offset against the attorney's fees owed by mother?
Never.
There's no court-directed offset that would come to play here.
No, if the $321 is actually child support for JY, which would be a due process violation, Mother never got that as an offset. She has been ordered to pay $310 a month. Father has not been paying her anything for child support. So that's why it makes no sense. I mean, the whole thing makes no sense. But just so the record is clear, yes, we did discuss possible settlement as oral argument approached, but at the time, Father was not interested. I do want to address the so-called disclosures in July 2015. First of all, again, they are not in the record. The family court did not have access to any disclosures. Frankly, if there were such financial disclosures in the file that I received from trial counsel, I would have a duty to inform this court that we received them. I did not see any. I was not able to get a straight answer because memories had faded about what was or was not disclosed. But I assure you that Mother does not believe that full required financial disclosures were made at that time. She agreed.
Stipulation by the parties to the numbers that they thought were appropriate.
There was not as to income, no, Your Honor. There was a so backstory to this July 2015 stip and order. Father owed Mother something like $25,000 in past due support and expenses. So as a compromise to get most of that money, Mother agreed that Father would pay $20,000 to her and that he would pay $1,800 a month going forward. There was no stipulation as to his income. There was no child support worksheet in the record that reflected his income at that time. And so, in the court's words, yes, the court did wing it on those numbers.
By the time you get to the next hearing, the cross petitions, at that point in time, did the court have in front of it numbers that would support the child support worksheet?
No, Your Honor. No, Your Honor. And Father Counsel characterizes the record, I believe, in saying that Mother didn't ask for that information and that she stipulated somehow to those numbers. And I would direct you to Index of Record 251 at page 17, which is her pre-hearing position statement, where she estimated that Father earned at least $400,000 a year, but noted she had no way of verifying this because, quote, Father has refused to provide any documentation relative to his income, even for this hearing, when both parties made modification of child support an issue, end quote. And so that was clearly a request that was made. And on pages, beginning page 239 through, I believe, 241 of the transcript, you'll see Mother's counsel trying to get into that issue, but basically being shut down. So there,
Down by whom?
By, unfortunately, page
Court deny her the ability to go there?
Was
it a stonewalling?
Do you have the transcript? I have that page. 241? Yes, it was counsel for Father.
That's my only question.
Yes. And the court backed her up. As far as whether this was a multiple children divided custody proper calculation, as set forth in the reply brief on pages 6 through 10, that calculation requires two worksheets. One for the mother's child support obligation and one for the father's child support obligation. Obviously, we've only got one worksheet here, and so that guideline was not followed, which is legal error. If the $321 was in fact child support for JY, which has never been paid, that is clearly a due process violation that at a minimum requires reversal. And now that it's 2 years since the July 15 stip and order, there should be no question that financial information should be exchanged. And with that, I will, as far as, I don't know, if you want me to address why they are modifying at this point, I think it's irrelevant, but.
We're out of time.
Yes, thank you, Your Honor.
The schedule is such that we probably can't do that today.
Thank you, Your Honor.
Thank you very much for your argument. Thank you for paying the attention you have to the questions we have, because that's clearly where our concerns are. We're going to take it under advisement at this time, and we will rule in due course. Thank you, counsel.
Thank you.